Companies Act Section 36, Punishment for fraudulently inducing persons to invest money. 1. Definition of the offense. Section 36 of the Companies Act establishes strict provisions against individuals who engage in deceptive practices aimed at inducing others to invest money. These practices include the intentional or reckless use of false statements, promises, or the concealment of material facts with the aim of misleading or defrauding potential investors or business partners. False statements and promises. An individual is considered to have committed an offense under this section if they knowingly or recklessly make any false, deceptive, or misleading statement, promise, or forecast. These actions are considered fraudulent if they are done with the intent to deceive or mislead another person into making financial decisions or entering into agreements related to investments. For instance, a person may make exaggerated claims about the profitability or value of securities, even though they know such claims are untrue, in order to persuade someone to invest. Concealment of material facts. In addition to making false statements, individuals can also commit an offense by deliberately concealing material facts. Material facts are pieces of information that, if known, would likely affect the decision-making process of a reasonable person. By withholding such critical information, the individual induces others into making financial commitments based on incomplete or inaccurate data. This concealment can be just as damaging as an outright lie, as it prevents the investor from fully understanding the risks or realities of the proposed investment. 2. Scope of inducement. Section 36 outlines the types of activities and transactions that are covered under this provision. The deceptive actions or concealments must be carried out with the intention of inducing another person to engage in certain financial agreements or transactions. Securities transactions. The first category of inducement involves transactions related to securities. The offense covers instances where the individual attempts to induce someone to acquire securities, persuading an investor to purchase securities based on false or misleading information, dispose of securities, convincing an investor to sell or transfer their securities under false pretense, potentially causing them to lose money or miss out on potential profits. Subscribe for securities. Inducing someone to subscribe to newly issued securities by providing deceptive or inaccurate details about their potential value or the company's financial health. Underwrite securities. Persuading an individual or institution to underwrite securities, taking on the risk of purchasing them if not fully subscribed by others, based on false information about the company's prospects or the demand for the securities. Profit agreements. Another form of inducement addressed by Section 36 involves agreements that purport to secure a profit for one party based on securities transactions. This includes agreements where profits are expected to be made through the yield of securities, promising an investor returns based on interest, dividends, or other yields from the securities, when such claims are exaggerated or entirely fabricated. Fluctuations in the value of securities. Suggesting that an investor can profit from anticipated changes in the market value of the securities, even though the predictions are based on false data or a misrepresentation of the market conditions. These inducements are particularly harmful because they exploit an investor's trust in the accuracy of the information provided and may lead to significant financial losses if the true nature of the securities or the agreement is revealed too late. Credit facilities. The third form of inducement covered by this section relates to agreements aimed at securing credit facilities from banks or financial institutions. Fraudulent actions in this area involve inducing someone to obtain credit, persuading a person to enter into agreements where they receive credit or loans based on false information or concealed risks, The person making the fraudulent claims may seek to profit by misrepresenting their financial position, the value of the securities being offered as collateral, or the overall soundness of the investment opportunity. 3. Legal consequences. Individuals who engage in any of the fraudulent activities described in this section are subject to the penalties outlined in Section 447 of the Companies Act. Section 447 deals with criminal liability for fraud and imposes severe penalties on those found guilty of committing fraud in connection with company affairs. Action under Section 447. Under Section 447, the penalties for fraud can include imprisonment. Depending on the severity of the offense and the degree of deception involved, individuals found guilty of fraud can face significant prison sentences. Fines. In addition to imprisonment, the court may impose hefty fines, the amount of which can vary based on the scale of the fraud and the financial losses incurred by the victims. Other penalties. Individuals may also face other legal consequences, including disqualification from holding certain positions within companies or being prohibited from engaging in securities transactions for a specified period. The penalties imposed under Section 447 are designed to reflect the seriousness of the offense and to deter others from engaging in similar fraudulent conduct. The law takes a strong stance against any form of deception that undermines the integrity of financial transactions and the trust of investors. 4. Purpose of the provision. The overarching purpose of Section 36 is to protect investors and the general public from being misled or deceived into making financial commitments based on false or incomplete information. The financial markets operate on trust, and any attempt to manipulate that trust for personal gain threatens the stability and transparency of the investment environment. By holding individuals accountable for fraudulently inducing others to invest money, the law reinforces the importance of honesty and transparency in financial dealings. The provision seeks to maintain the integrity of capital markets by ensuring that investors have access to accurate, truthful, and complete information before making investment decisions. Investor protection. Investors often rely heavily on the statements and promises made by companies, brokers, and other financial agents when deciding whether to invest their money. Section 36 provides a critical safeguard for these investors by establishing clear legal consequences for those who would seek to exploit their trust through deceit or misrepresentation. Preservation of market integrity. The provision also serves a broader purpose of maintaining public confidence in the financial system. Fraudulent activity not only harms individual investors but can also damage the reputation of the entire market, leading to a loss of confidence and reduced investment. By deterring fraudulent inducements, Section 36 helps to preserve the integrity and reliability of financial markets, fostering an environment where investors can make informed decisions with confidence.